Infringement. Infringement refers to the use of intellectual property without permission or without consent. Now, this use is obviously by a third party. When infringement happens, and we saw the different types of infringement with regard to patents, trademark, copyright, and designs, and how they these rights at some place overlap with each other, the recourse for a person whose right has been infringed is to go to the courts. Now, the infringing acts can themselves be classified broadly as primary infringement, where the infringer directly infringes the act. The act of infringement is directly attributed to the infringer. Or they could also be secondary. Secondary in the sense that there are other parties who help the person in the infringement. There are groups or parties who help in the infringement. For instance, if you have a patent for a drug and your competitor also manufactures the same drug but without a patent protection. So, in the eyes of law, the competitor is an infringer. Now, he not only manufactures it, he supplies it and distributes it to different parts of the country. So, he has a distributor who collects the drugs from the manufacturing unit, and he has got retailers who sell them in pharmacies. So the distributors and the retailers can be considered as people who indirectly or who contribute to the infringement. So indirect and contributory infringement are aspects of secondary infringement. So we refer to something as secondary, where the person's involvement is indirect but it helps or aids the infringement. Primary infringement, where the act is directly attributable to the person who infringes. For instance, as we just mentioned, the competitor who manufactures the drug, making a patented article is one of the rights protected under the Patents Act, and making the article or manufacturing it is an act of direct infringement. Now, the remedies a person has can be civil, it can be criminal, and it can also be administrative. By administrative, we refer to the remedies that a person can have before the patent office. Patent infringement is not defined under the Patents Act, but we understand that any right that is granted under the Patents Act, if there is a violation with regard to that right, then it can be construed as infringement. So, Section 48 of the Patents Act details the rights that a patentee has. Their rights can fall broadly within two categories. It could be with regard to product, what we call product patents, or it could be with regard to processes, what is called as process patents. Now, these rights pertain to manufacturing or making, sale or selling, offering for sale, which can be regarded as marketing, using, and import. So, these are the 5 types of rights that are covered under the Patents Act. So, any other person who makes, uses, sells, offers for sale, or imports the process or a product that is protected without the consent of the patentee, then we call that infringement. So it's not defined by case law, and by convention we understand infringement as an intrusion into the right guaranteed under the Act. The level of intrusion is also important, because in patent law, the level of intrusion can be ascertained by looking at the scope of the patent claim. The patent specification has a claim, and the claim is where a person either says I claim or we claim or what is claimed, and they mention the aspect of the inventions for which they claim protection. Now, the act of the infringer may not fully map onto the claim. There could be certain aspects of the act that are mapping, and could be certain aspects of the infringer's act which may not be falling within the scope of the claim. So, that is an exercise that the court will have to determine the level of intrusion before it comes up with a finding of infringement. A patent specification is granted with the claim, and the claim describes the scope of the invention. we find this in the Patents Act. Section 10 says that the scope of the invention is defined in the claims for which protection is granted. So in patent infringement, unlike trademark and copyright, there is an assessment of the scope of what is protected by reading the claim and by interpreting the claim, and there is a mapping of the act to the scope of the claims. So there are two things. You look at the infringing act, it could be a product or it could be a manufacturing process, and you see whether the infringing act falls within the scope of the patent. Now, to determine infringement, the first thing that the courts would do is to look at the scope of the invention as per the claims. Now, it may not be apparent on a plain reading of the claim. The court may have to construct the claim where the language is not clear. The court may also seek assistance if the language is too technical. If the subject matter is technical, the court can always get the assistance of experts. Once the court ascertains the scope of the invention as per the claims, then the court will ask the question whether there is a violation of any of the rights of the patentee. So this we mentioned, section 10 talks about the fact that the claim should define the scope of the invention and the claim is what is protected. So the scope is ascertained. Then the court sees whether any right is violated. For instance, we mentioned that the 5 rights a patentee is protected are mentioned in section 48: manufacturing, selling, offering for sale, import and using. Once this is done, these 2 steps are done, the court will determine who is liable for the act. Now this comes because there is an infringing act against which a case has been filed. Now the liability, as we saw, could be primary or secondary. So the court will do the determination as to who is primarily liable. And finally, the court will look at whether the act comes under any of the exceptions. Now we have some exceptions in patent law. Section 47 has a set of exceptions which cannot be taken action against. Then we have in section 107 A and B, we have some exceptions which would not amount to infringement. In section 140, we have certain protections which could be claimed in case of a infringement. So the exceptions, the court will look into the exceptions. So once the court goes through this 4-step process and it finds that it has cleared all these steps, then the court will say there has been an infringement of a patent. It is important that the patent can only be enforced during the term of the patent, meaning which during the time the patent is alive. Now the term can be kept alive by regular payment of renewal fees. Now renewal fees, if it is not paid, then the patent would lapse. So it has to be paid on an annual basis. Assume that a case where a patentee does not pay the renewal fees and for a year, and the patentee tries to enforce the patent with regard to infringing acts which have been happening during the time when the patentee's patent had lapsed. The patentee will not be able to enforce the patent because the time during which the infringement happened, the patentee had not paid the fees to the patent office to keep its patent alive. So renewal is an important aspect of infringement. The first thing a person would do when there is an infringement case against that person is to see whether the intellectual property right has been kept alive. If there is a default in the payment of renewal fee, which consequently gives a defense for the infringer in the sense that the patentee cannot enforce the patent during the time when the renewal fee was not properly paid. And we had already mentioned this, the infringement should be with regard to only a product or a process, because the patent protection is only for either a product or a process. And it should be with regard to the 5 acts: making, using, offering for sale, selling or importing. Now, jurisdiction refers to the courts which will have power to take up the matter. Now, the Act says it can be filed before a district court, or it could also be filed before the High Court. Now, district court is the lowest level where you can file a patent infringement case. But the Patents Act provides that if in the case which is filed before the district court, the infringer makes a challenge to the patent. Now, challenge to the patent can be a defense in an infringement suit. If the patentee enforces the patent, the infringer can in return say that, how can you enforce a patent? I am questioning the validity of the patent. So when the question is with regard to the validity of a patent, then the law states that the matter cannot be decided by the district court. It has to be transferred to the High Court. So that's a provision in the law, and there is some wisdom behind it. So the district court could be the first place where you can file an infringement suit, but if the infringer raises a challenge to the validity of the patent, and we find that in most patent infringement cases, challenge to the validity is something which a defendant would raise, then it has to be transferred to the High Court. So it is safer in some cases to directly file the case before the High Court, expecting that a defense of invalidity could be raised by the defendant. Now, the High Court has an appellate side and it also has the original side. So the patent cases are filed in the original side of the High Court, and the ability for the court to decide a case will depend on the relief that is claimed, because there is something called pecuniary jurisdiction which tells us the value of the cost, which tells us that the value of the case will determine which court will look at it. Now, where can the patentee file the suit? The patentee can file the suit at the place of residence or the place of business of the defendant. So the case has to be filed where the defendant is, or rather where the infringement happens, and the court where the infringement happened or where the defendant resides will have the jurisdiction with regard to taking up the matter. Trademark infringement is different from patent infringement, because in patent infringement we saw construction of the claim which has been granted protection and mapping the infringing act to the scope of the claim, looking whether it fell within any of the rights of the patentee, and also looking at whether they pertain to any of the exceptions. Now, in trademark, the infringement is determined by a simple comparison. Now, the registered mark used by a person, not a registered proprietor or licensee, can be enforced in an infringement proceeding. The use of the infringing mark should have been in the course of trade, and the infringing mark should be identical with the registered mark, or it should be deceptively similar in such a way that it causes confusion. So these are the requirements. That's why I said the test for infringement in trademark is a very simple test of comparison. If the two marks are kept next to each other, and if they look identical, or if they are deceptively similar such that it can cause confusion to the layperson, then infringement is determined. And the mark should be with regard to goods and services. Now, for well-known marks, the use of an identical or similar mark for both similar and dissimilar signs can be a subject matter of infringement. For instance, Munchie Burger is something which a person can have as a mark, trademark, but if the Munchie Burger is shown with the McDonald's M at the background, then that would amount to an infringement. So this is not allowed by law, whereas the Munchie Burger by itself is a mark that can be allowed. So this is a protection that is given to marks that are well known. Jurisdiction in a trademark case, again, you can file it before the district court or the high court, and the registered proprietor can file a civil suit. Any person can file a criminal suit for false descriptions. We have mentioned that there are criminal sanctions in trademark law. And more importantly, a person can institute the suit where he resides. So the place of jurisdiction is that of the plaintiff, not of the defendant. So the person who chooses to file the case can file it where the person resides or carries business. Unlike patent law, there is no need to go after the defendant who could be in a different city or a different place. Copyright infringement protects the right of reproduction, the right to make copies, and piracy is one of the ways in which infringement happen. Mass copying of a copyrighted work is what we refer to as piracy. Now, the reproduction in any material form is covered. For instance, if a book is scanned and a video is uploaded, it is still copyright infringement. And the copying should be substantial. Substantial as in a good amount of the book should have been copied. A few pages, say photocopying a few pages, may not amount to copyright infringement. And again, you have in two different types of copying. It could be copying can be direct copying, or it could be indirect. Indirect in the sense that it's not a replica, but the substance has been copied from the copyrighted material. Jurisdiction, again, it's with the district court and the high court. The registered proprietor can file the suit, and it can be filed again where the person instituting the suit resides. Like trademark, it could be filed where the person who institutes the suit resides. And like trademark, you again have criminal and civil remedies.